Welcome to the deep dive. So, you sent over some really interesting material on Turkish law of obligations, foundational stuff.
That's right. Yeah, it's the bedrock for a lot of interactions.
And that's what we're diving into today, trying to unpack it, make it clear without, drowning in legal jargon.
Exactly. The mission is clarity. What is this law of obligations? What's a debt relationship?
Okay, so a debt relationship. That's basically where one person owes something to another. Is that the gist?
Pretty much.
Oh.
A debtor has an obligation to perform some behavior for a creditor. Could be an individual, could be a company.
And that behavior, like what kind of things?
Well, it falls into three buckets, really. Giving something like you buy a book online, the seller has to give you the book.
Right. Makes sense.
Or doing something. Think hiring a painter. Their obligation is the act of painting.
Okay.
And sometimes it's not doing something, maybe agreeing with your neighbor not to build a high wall that blocks their view.
Ah, interesting. So it covers inaction, too. That online album purchase you mentioned.
Right.
That fits the giving something idea.
Perfectly. And it shows it works both ways, doesn't it?
Yeah.
You have an obligation to pay. The seller has an obligation to deliver the album file.
Oh.
Reciprocal.
Got it. So where do these rules actually come from? Is there one main law?
There is. The primary source is the Turkish Code of Obligations. That's law number 60988.
6098. Okay.
And it's got two main sections. Part 1 is general provisions. Those are the core principles we're mostly looking at. Part 2 is specific debt relationships.
So general provisions, those apply to pretty much any debt situation.
That's the idea. They lay the groundwork. Then the specific part details common contract types, sales, leases, service agreements, things like that.
Are there other laws involved, or is it all in that code?
Oh, other laws definitely play a role. The civil code is huge, the commercial code for business stuff, even consumer protection law can have relevant bits.
Right.
And then you have, court decisions, jurisprudence, and what legal scholars write doctrine. They help interpret everything.
Customary law. Not so much in this area, very limited.
Okay, so the code is central, but it connects with other areas. How does it fit into the bigger legal picture, like with civil law?
It's a major branch of civil law. There's actually an article in the Turkish Civil Code, Article 5, that basically says the general rules from both the Civil Code and the Law of Obligations apply broadly across private law.
So they're tightly linked. What about business law, commercial law?
Yeah, so commercial law often has its own specific rules for, say, a sale between two merchants. Those specific rules usually take priority.
Okay.
But if there's a gap or something isn't covered by the commercial rules, they often look back to the general principles in the Law of Obligations. It provides the foundation.
And does the Constitution influence this at all? Fundamental rights?
Absolutely. Things like freedom of contract, that's Article 48, and property rights, Article 35, they shape how these obligations are understood.
Well, they set boundaries. Plus, the Constitution mentions the principle of a social state in Article 2. That often translates into protecting the weaker party in a contract. Think consumer protection, employee rights.
That makes sense. So let's dig into the core ideas then. What's the main principle driving this?
The big one, the cornerstone, is the principle of freedom of will, sometimes called autonomy of will.
Freedom of will, meaning?
It means, generally, individuals are free to shape their own legal relationships. They can decide how to interact, legally speaking, as long as they stay within the law's boundaries.
And the biggest expression of that is freedom of contract.
Exactly. That's the most important manifestation. It covers several things, like the freedom to enter a contract or not to.
You can just say no.
Usually, yes. Also, freedom to choose who you contract with, and freedom to decide the terms and conditions. Plus, generally, there's no requirement for a specific form, like writing, for many contracts.
But surely there are limits. You can't have total freedom, right?
Oh, definitely not. There are exceptions. Think about monopolies or essential public services like transport. Sometimes you might be obligated to contract.
Like mandatory car insurance.
Precisely. Or services offered publicly. The law sometimes steps in for the public good or to prevent abuse.
Okay. Now let's zoom in on the word debt itself. You mentioned a debt relationship. Is debt just one thing?
We use it in two ways. In a narrow sense, yes, a debt can be a single specific performance. The thing the debtor has to do, give, or not do, like the obligation to pay £100. Simple.
And the broader sense?
The broader sense is the debt relationship. That's the whole legal bond between the parties. It can include multiple debts, rights, ancillary duties, like the duty to act in good faith.
Like an employment contract that involves lots of different obligations.
Exactly. Salary payment, doing the work, confidentiality, it's a whole package. That's the debt relationship.
So what are the essential bits of this relationship?
You need the parties, obviously. The creditor who is owed something and the debtor who owes it.
Can you be both?
Definitely. In reciprocal contracts, like buying coffee, you're the debtor for the money, but the creditor for the coffee. The cafe is the reverse.
Right. What else?
The other key element is the performance. In Turkish legal terms, idim. That's the actual object of the obligation.
The what? What the debtor has to do, give, or not do.
Exactly. And this performance has to meet certain criteria. It needs to be definite, or at least determinable.
I have to know what it is.
Right. It must be lawful and moral, can't violate public order. It has to be possible to perform. You can't agree to sell the moon.
Makes sense.
And it can't violate fundamental personal rights.
Okay. And are there different types of performance?
Oh, yes. Lots of ways to categorize them. We talked about positive giving or doing versus negative not doing, like a non-compete clause.
Mm-hmm.
Then there's whether the debtor's personal skills matter. Is it personal, like hiring a specific famous surgeon? Or material, where it doesn't matter who does it, like delivering standard bricks.
Okay, that's a clear distinction.
We also look at duration. Is it instantaneous, happens in one go, like a cash sale? Continuous ongoing, like a lease agreement? Or periodic recurring actions, like monthly rent payments?
Right, rent is a good example of periodic.
And divisibility. Can it be performed in parts, like a money debt? That's divisible. Or must it be done as a whole, like delivering a live horse? That's indivisible.
You can't deliver half a horse.
No. Hopefully not. Lastly, how is it defined? Is it generic, defined by type and quantity, like 10 kilograms of standard flour, or specific, individually identified, like that specific painting by that artist?
And that matters if something happens to it, right? Like if the specific painting is destroyed.
Exactly. For specific goods, if it's destroyed accidentally before delivery, often the obligation ends. For generic goods, the rule is genus non parat. The type doesn't perish. The seller usually just has to find more of the same type. There's also alternative performance, where the debtor can choose between two or more options.
Wow, okay. So even within the idea of performance, there's a lot of detail. It really shows how this framework underpins so many different agreements we make.
It really does. It's the hidden structure, isn't it?
Yeah.
And thinking about it, this whole system, it really relies heavily on, well, trust and mutual expectation between people.
That's a really interesting point. The law provides the rules, but society needs that baseline trust for it all to function smoothly day to day.
Precisely. These principles aren't just abstract legal concepts. They reflect how we try to manage our interactions and rely on each other's promises.
Well, thank you. This has been a fantastic deep dive into just the foundations. It certainly gives you a new way to think about even simple transactions. So the question to ponder then is, what does this structure reveal about how we actually build and maintain that trust in society? Something to think about. Until next time.